were running parallel, the Bunge Mashinani as well as the designated county assembly. The governor is also accused of appointing Dr. Peris Nyaboke Oroko alias Peris Ngare to the county executive committee without the approval of the county assembly. Also, the appointment of Nyamira and Keroka municipalities board members without the approval of the county assembly of Nyamira, and also appointing of a selection panel for recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board without the approval of the county assembly of Nyamira. And the sixth allegation regards failing to appoint the chairperson, secretary, and members of the Nyamira County Public Service Board. Now, these were allegations or charges that were read to the governor in the morning when he took plea, and he pleaded not guilty. Further charges include failing to submit annual reports and deliver an annual state of the county address to the county assembly for 2 consecutive years, and also by failing to appoint and obey court orders regarding the appointment of Clive Ogwora to the county executive committee. The governor is also accused of abuse of office. That is the second ground. Under this, the governor is accused of abuse of office by improper use of his authority in recruitment of staff without approved budget. The governor is also accused of influencing the appointment of Godfrey Kriago and Elmelda Nyaberi as Director of County Human Resource Management and Assistant Director Human Resource Management, respectively. Also, that through personnel enrichment from receipt of irregular salary arrears amounting to 5.6 million Kenya shillings, and also abuse of office through systematic payroll fraud and syndicate.
The governor of Nyamira, Amos Nyaribo, is facing so many charges against him. He's being accused of misuse of office, misappropriation of county resources, failure to submit reports, annual reports, as required by the law, and also on appointments, illegal appointments of people to the county. So this afternoon, the Speaker of the Senate is going to rule on the issues which were raised in the morning, and we will know the fate of, we will know what comes next. The senators are already seated at the Senate, the floor of the Senate. They are waiting for the Speaker to enter the chambers, and then they will proceed.
Approximately 32 million shillings, and also abuse of office by influencing dual appointments outside the lawful establishment. Under the abuse of office, the governor is also facing a charge regarding usurpation of powers of the Auditor General and the County Public Service Board and violation of due process through illegal payroll, audit, and demotions. These are some of the charges the governor is facing. However, in the morning, when the charges were read out to him by the clerk, both grounds, the governor pleaded not guilty, and that set the pace for the preliminary hearings to begin, with the governor's side bringing up the preliminary objections regarding the threshold, on whether that particular threshold was met or warrants that particular motion.
The Speaker of the Senate said that he's going to rule on those issues at 2:30 p.m. It is already 2:41. This is a bad sign that the Senate, one of the most respected institutions in Kenya, does not respect the time, which is not a good show. But we can see members of the Senate or senators coming in as we wait for the Speaker to come in and provide the ruling. Already, the governor of Nyamira, Amos Nyaribo, and his team, you can see them seated over here. This is Amos Nyaribo, and maybe his lawyers are already seated there. And of course, we have on this side of the floor, we have a lawyer for the Senate already seated.
This is a matter that is coming up for ruling this afternoon. The Speaker indicated that he will be giving a ruling regarding the preliminary objections, as the governor's legal team is indicating that there is no clear threshold to give the motion some life for it to be able to proceed on to the next stage. The matter stems from the total number of members of County Assembly.
I can see Senator Okia Umtata over here, a very hard-working senator from Busia County, is already in the house.
Elected or represented in the County Assembly of Nyamira.
Also, Senator Richard Onyonga of Kisii is in the house. Senator Olekina of Narok is in the house. Those are the senators I know.
As well as the number of the members who were present during the voting of the motion, vis-a-vis the number of members.
Senator Okongo Mogeni of Nyamira County is already in the house.
Who supported that particular motion. Remember, 23 out of the 32 that were present voted to support that particular motion. However, the question that is coming up is whether the 2/3 threshold was met regarding the number of members, that is the total number of the county assembly members or members of the county assembly, and the ones that were present during the time that the motion was being moved at the county assembly. If you're just joining us, is that the House is about to resume the hearing and determination on the proposed removal from office by impeachment of Honorable Amos Nyaribo, that is the governor of Nyamira County. He is facing an impeachment motion. And
why did even people call him Kemoni? Why? Is that a name of a person really? I come from that county, but I find the name funny.
The Senate has that mandate as a quasi-judicial mandate. So the hearing has already begun. However, in the preliminary remarks, there were objections that were raised by the legal team from the governor's side, ones that were also dismissed by the legal team from the county assembly side. So the speaker is meant to make a ruling on that for the matter to be able to either continue or be terminated regarding on whether there is threshold for that motion to stand. So the members are already in the chamber. We are just waiting for the speaker to be able to make his way inside for the business to be able to continue. Remember, both sides are inside the chamber, that is the governor's side. The county assembly legal team include Katwa Kigen, Mokua Ndumbi, as well as Doris Ngeno. And the governor's legal team include Elias Mutuma, Zelma Bonuke, Omuira Temo, Brian Lee Orina, Erastus Orina, Sylvia Njoki, as well as Michelle Makandi. Once the ruling is made, that is in favor of the county assembly side for the motion to be able to continue in the House, then the county assembly will be able to give out evidence to present.
This is the senator for Homa Bay.
It's evidence before the Senate. This is a plenary sitting. The House is considering the matter in full House, in plenary, as opposed to a committee. That particular motion for the impeachment hearing to be done the committee way flopped last week in the chamber, and the members of the Senate adopted the plenary way to hear and determine on this particular matter. So this is a full House. All senators are able to follow on the presentations from both sides, that is the county assembly, that are making their case. They will be able to present all the evidence that they deem fit to be able to make their case concrete. The governor's side will also be able to give their presentations to be able to counter any accusations that the governor is facing or that the county assembly will present. At this point, if there are any witnesses, any affidavits that were shown, any audio that is to be played, any video that is to be played, any witnesses that are to be called upon to give their testimony, that is the presentation of evidence that will be done.
So this is where the senators pick their waters from, the table in the middle of the Senate floor.
By either side, in a way that to ensure that each side is able to defend its position. By all means, we will also see the cross-examination of the witnesses, as well as a re-examination of the witnesses, that is from both sides of the legal team. That is the next process that will be following at the time the ruling that is made by the Speaker, if either the motion will be upheld to be able to proceed or to move on to the next stage. That is all to be made clear once the Speaker makes his way into the chamber to be able to enlighten on the position that the House has taken regarding this particular matter. This is the impeachment process, the hearing and determination of the proposed removal from office by way of impeachment of the governor of Nyamira, that is Honorable Amos Nyaribo, after 23 of the MCAs in the county assembly supported this particular motion and forwarded the motion to the Senate to be able to consider the allegation.
All right, so online, maybe as we wait for the session to begin at the Senate, already on the National Assembly, they have said some more information is that the Senate is set for Nyamira Governor Amos Nyaribo's trial. So all preparations have been finalized for the Senate to begin impeachment hearings against the Nyamira County Governor Amos Nyaribo, with proceedings slated for Wednesday, of course, and Thursday. So it will happen for today and tomorrow. The plenary hearings, during which the full House will convene, and as the trial court are expected to be closely watched by as senators decide the governor's political future. The process will formally open on Wednesday, which is today, with the reading of the charges leveled against the Governor Nyaribo. He will then be required to enter a prayer, either admitting or denying responsibility, of which he already denied responsibility in the morning session. So this afternoon, we are largely looking forward to
or the charges
towards a ruling on those on what happened in the morning session. The County Assembly, which initiated the impeachment, will represent its case first, outlining evidence, which is a good thing, and then they already outlined the evidence and arguments to support the governor's removal from office. The Assembly's legal team is set to table documents and cross-examine witnesses to reinforce its claims. Governor Nyaribo defense team will subsequently be granted an opportunity to respond. They are expected to challenge the allegations, call their own witnesses, and subject them to cross-examination. And then Governor Nyaribo was impeached by the County Assembly. Some background information. He was impeached by the County Assembly of Nyamira on 2 grounds. One was violation of the Constitution and other rules and abuse of office. So abuse of office, gross violation of the Constitution and other rules, and abuse of office generally. Those are the 2 key grounds on which the governor was impeached. Under the first charge, Governor Nyaribo is accused of engaging in or endorsing and supporting unlawful and unconstitutional Bunge Mashinani initiative, giving illegal assets to Nyamira County Supplementary Appropriation Bill 2024, and making unlawful appointment of Dr. Peris Nyawoke Oroko, also known as Peris Mongare, as the County Executive Committee member. So that is the issue. Also, it is further alleged that the governor illegally appointed members of municipal boards of Nyamira and Keroka and lawfully constituted a selection panel for the County Public Service Board, and of course failed to appoint the chairperson, secretary, and members of the County Public Service Board. The County Assembly accused Nyaribo of failing to deliver the State of the County Address and annual reports, as well as failing to comply with court orders regarding the appointment of Mr. Cliff Owora to the County Executive Committee. On the charges of abuse of office, Nyamira County Assembly faulted the governor of conducting staff recruitment without budgetary provision, influencing irregular appointments of senior human resource officials, and enriching himself through irregular salary arrears. Members of the County Assembly additionally cited a payroll fraud syndicate that resulted in the loss of public funds and the governor's involvement in dual appointments outside the lawful establishment and usurpation of powers of the Auditor General in the County Public Service Board. Amos Nyaribo is also accused of unlawfully suspending the secretary of the County Public Service Board, Majority Leader Aaron Cheruyot, Senator, had initially moved a motion to establish 11 members select committee to handle the proposed removal through impeachment, but it collapsed after it failed to get seconder, paving way for the full plenary hearing. The Speaker directed the clerk of the Senate to issue invitations to appeal to the parties on Thursday, 27th November 2025, and of course instructed the parties to file their responses with the office of the clerk of the Senate by Monday, the 1st of December 2025, which was 2 days ago at 5 p.m. The clerk was further directed to circulate all documents received from the parties, including plenary hearings, program to all senators by close of business Thursday, 2nd of December 2025 at 5 p.m. So we are waiting to hear how this will go as we wait for the speaker to get back to the house. Though he said he will start the proceedings at 2:30. It's already 2:58, which means the house is lagging behind in terms of what they had promised to deliver. So there is no following time in the Senate because he clearly said that the meeting was to start at 2:30, but now it's already 3 p.m. and the program has not yet started. So we shall continue watching this space to make sure that we are on top of things. We are on top of things as we wait for the Senate to resume. Meanwhile, we should see what people are saying online about this impeachment of Amos Nyaribo on Twitter. We start with Twitter, then later on we will go to Facebook. We see what Kenyans are saying about the impeachment motion. So far, so good. A number of governors have already been impeached in the past, including Governor Mike Sonko was impeached in the past successfully, and also the governor of Isiolo, governor of Meru was also impeached. So impeachment of governors in Kenya is a very active activity. Governors are being impeached here in Kenya from time to time. So this is an ordinary activity which happens from time to time, and it is very normal for governors to be impeached in Kenya, especially when they don't follow the law or when they mess up with how they are doing their work. Actually, it is funny that the impeachment motion of Governor Amos Nyaribo is not trending on Twitter. It is nowhere to be seen. Maybe it is not on top of the agenda for Kenyans, or maybe Kenyans don't know him. He's not very popular. Maybe that is why. So we are forced now to search. Maybe we can search for Amos Nyaribo to see what Kenyans are saying about this governor of Nyamira County. Let's check it out. All right. This is from 3 hours ago. Let us check if the account of Amos Nyaribo, they have commented anything. Governor Nyaribo, if they have commented anything, we will get to know right now. The last person who spoke about this was Minto FM. This happened at 3 hours ago. They said they were reporting that the governor had arrived at the Senate of Kenya in readiness for the impeachment motion. So KBC is saying that the embattled governor, Amos Nyaribo, has pleaded not guilty to 6 charges leveled against him as the Senate began hearings of his removal from office by impeachment. Here's the news.
County Assembly, the governor's lead counsel. Welcome back. Embattled Nyamira Governor Amos Nyaribo has pleaded not guilty to charges leveled against him as the Senate began the hearings of his removal from office by impeachment. Nyaribo, who took the stand on Wednesday before the plenary, denied responsibility for 6 charges he is facing, including support of unconstitutional bunge machinani and making appointments without the approval of the county assembly. The governor's lead counsel, Elias Mutume, while making his preliminary remarks, urged the Senate not to allow the impeachment motion to proceed to the next stage, saying it does not meet the threshold. However, the county assembly lead counsel, Katwa Kigen, disputed the preliminary objections, arguing the motion has met all the requirements and ought to be considered to its logical conclusion, rather.
All right, I think we go back to the Senate.
His Excellency Amos Kimomi Nyaribo presided over and influenced the approval of recruitment of staff without an approved budget as demonstrated in County Executive Minutes MIN number 04/02/2021 of 26 February 2021 in his response to an inquiry from the Controller of Budget. This recruitment was approved by the County Executive with full knowledge that there was no budgetary provision. In the said response to issue number 4 in the question, the Governor alleged that in lieu of the budget, the recruitment was based on the savings made from various separations, which included but not limited to recruitment and resignations. 2, despite a resolution of a county assembly to freeze new employments on account of lack of budgetary provision for any recruitment dated 1st July, Honorable Amos Kimomi Nyaribo, how do you plead to the 2 grounds, guilty or not guilty? Ground 1.
Not guilty.
Ground 2.
Not guilty.
Welcome back.
In the House last week for the matter to be considered by an 11-member committee. However, that matter flopped, rendering the motion to be considered by the whole House, that is, by the full House of the Senate, each senator being able to follow up on the presentations and submissions that the 2 parties are presenting for this, or rather regarding this matter.
Not guilty.
But remember, if the
Not
Speaker
guilty.
rules in favor of the County Assembly, that is for the matter to be able to continue, or the motion to be able to continue, then both sides will have an opportunity to bring on board their evidence, especially the accusers of the governors.
As we wait for the governor, as we wait for the Senate Speaker to come back, let us listen to Amos Nyaribo.
My name is Amos Nyaribo, Governor of Nyamira County. Today, our students have started their examinations. We take this first opportunity to wish them success. And the first batch of our scholarship students are also doing the first examination this year. There are 235 students whom we selected from villages, taking poverty index as the first.
So if you don't know Governor Amos Nyaribo, that is what he looks like, and that is how he sounds like. He's the governor of Nyamira, first time governor. He had served part of the term which was supposed to be served by former governor of Nyamira. And now he's on a new term. He was elected for a 5-year term. But it seems he's in trouble, especially with the county assembly. So that is why today he's at the Senate to face the senators to respond to the charges against him. So this is an impeachment motion. So the session looks like it's running late. There isn't much which is being discussed online. All right, so meanwhile, as we wait for the chamber to come back to life, maybe some people are saying that Nyamira Governor Amos Nyaribo names 7-member defense team led by Elias Mutuma, while his senior counsel, Kato Kigen, leads the county assembly's prosecution in impeachment hearings. So Kato Kigen is representing the county assembly in this impeachment motion. So Elias Mutuma is the lead defense member for Amos Nyaribo. So they went for Kato Kigen. This is a serious lawyer who represented William Ruto at The Hague. Mutuma, it would be remembered that Elias Mutuma was the legal counsel for Meru Governor Kawira Mwangasa during our impeachment proceedings at the Senate. So Elias Mutuma is not new to the Senate proceedings. He's not new to the Senate proceedings. Elias Mutuma has experience working with the Senate because he has previously represented the Meru governor who was impeached successfully. So Nyaribo decided to go for him to represent or to lead his defense counsel or his defense team at the Senate, while the county assembly went for Katua Kigen, who had represented Ruto at the ICC. So this is Elias Mutuma on LinkedIn. Is some information about him. He's the advocate and founding partner for the last 13 years. That is all the information provided here on LinkedIn about Elias Mutuma, the team leader of Amos Nyaribo's defense team. So we shall continue checking out for relevant information in regards to the ongoing impeachment motion of Governor Amos Nyaribo of Nyamira County. All right. Already All right. So we shall continue monitoring this situation because we cannot avoid politics. Politics affects our lives. Politics is what causes us either to have improved lives or to have lives which are doomed to fail because of the kind of leaders that we elect into public offices. So this is everybody's business to be an active citizen of the country. So this lawyer, Elias Mutuma, according to, there is a Facebook account here called Elias Mutuma. They say he's an advocate at Mutuma Gishuru Advocates since 2016 up to now. He's advocate at Mutuma Gishuru. Okay, that's okay. He studied at Canberra International University. He has a bachelor's of law from Canberra International University. He also went to Kahaga Boys, where he sat for his KCSE exams in the year 2000. He's a lawyer who studied at Canberra International University of Uganda. According to this profile on Facebook, this is what he looks like. That is Mutuma for you, the lead advocate for Amos Nyaribo. He's leading the defense team of Amos Nyaribo. So that is what is happening. We continue looking for more information as we wait for the Speaker of the Senate to get back. It seems it is taking more time for the Speaker to prepare his ruling. It's taking time for him to prepare his ruling, but we are prepared to wait as much as it takes in order to know what is the verdict for today. So we are here waiting. We have no hurry here in Africa. We will wait until we hear what is happening, what will happen, what will be next. So in the comment section, you can tell us what you think. Will the governor be spared? Will he be spared? Or will he go home the way Sonko went home? We are yet to know. We are here to know what you think. You can go to the comment section and let us know what you think. Let us know what you think in the comment section. Will the governor be spared or is going home direct? What will happen to him? Let us know in the comment section as we wait. Oh, okay. We get back to the house now.
As well as Kon himself, an irregular made their way to the Senate. And this afternoon, the business or the procedure in the hearing and determination continues. The Speaker of the Senate, Honorable Amason Jeffa King, is in the chamber to resume this debate. Allow me to hand you over to the proceedings.
Na tuombe. Ewe Mwenyezi Mungu, twakusihi ututazame kwa neema nyingi na baraka, sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Twakuomba utuwajalie tuyatende na kufikiria mambo yote atakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen.
So the Speaker of the Senate, Amason King, is back. Let us hear. Let us follow the proceedings together.
We do have quorum. You may proceed to call the first order for the afternoon.
Order number 1, communication from the chair.
Now, honorable senators, ladies and gentlemen, as you will recall, at the commencement of the hearing of the proposed removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County earlier today, Wednesday, 3rd of December 2025, Counsel for the Governor raised a preliminary objection to the hearing of the proposed removal from office by impeachment of Honorable Amos Nyaribo on the following grounds: that the impeachment motion dated 11th of November 2025 failed to attain the constitutional and statutory threshold, and that therefore the purported resolution for removal of the governor by way of impeachment was invalid and incompetent, as it failed to meet the mandatory threshold under Article 181 of the Constitution and Section 33 of the County Governments Act. And B, that the concept of proxy voting was alien, illegal, and null and void, and the attempt to explain the discrepancy through proxy voting was legally untenable and compounds the illegality of the proceedings premised on acts of fraud, forgery, and misrepresentation. Now, Honorable Senators, in urging the Senate to find that the threshold of 2/3 of all members of the County Assembly in support of the impeachment motion was not achieved, Counsel Elias Mutuma for the Governor stated that the County Assembly of Nyamira comprises 35 members, and that therefore the requisite 2/3 majority for a valid impeachment resolution was to inform members of the County Assembly. Council further submitted that the official record of the sitting of the County Assembly held on 25th of November 2025 confirmed that only 19 members were physically present in the Assembly chamber. Council stated that despite this, the Assembly recorded 23 votes in favor of the motion, and that this was numerically impossible, and that to him, this demonstrated that improper and fraudulent voting had occurred. Now, Counsel for the Governor submitted that the phrase "all the members of the County Assembly" in Section 33(2) of the County Governments Act is not ambiguous and refers to the total composition of the County Assembly as established under Article 177 of the Constitution and as gazetted by the Independent Electoral and Boundaries Commission after the 2022 general elections. Now, Council contended that as a membership of the Nyamira County Assembly is 35 members, and as 2/3 of 35 is 23.33, this can only be rounded off to 24 members. Now, Council further submitted that the County Assembly's argument that the 3 vacancies in the Assembly reduce all the members, end quote, from 35 to 32 was legally flawed and absurd. Council therefore urged that for these reasons, the impeachment proceedings before the Senate could not proceed and required to be terminated at the preliminary stage. Now, Council for the County Assembly took a different view on this matter. The thrust of the argument in response to the first preliminary issue was that the Independent Electoral and Boundaries Commission, IEBC, in Gazette number 9956 of 2022, published on 24th August 2022, set out the names of the elected members of the Nyamira County Assembly, and further that this was not the limit or absolute number of members who were required to sit in the Assembly at any given time. Council further noted that when the Constitution and the County Governments Act imposed the requirement of 2/3, this could only refer to 2/3 of the members present at any particular time. According to the Council, an alternative interpretation would mean that no activity could go on should there be a vacancy or a challenge in filling the vacancy, and further, that any business that has been transacted by the County Assembly of Nyamira on the basis of the members of the County Assembly of Nyamira at the time will be null and void. Council further stated that this issue is a question of fact that ought to be determined through the examination of evidence during hearing. On the second limb of the preliminary objection relating to voting by proxy by the 4 members of the County Assembly, Counsel for the Governor stated that this was alien to the County Assembly procedures, illegal and null and void. Council further stated that no authority was granted by any member to vote on the behalf by proxy, and that the 4 members of the County Assembly in whose names proxy votes were recorded had provided sworn statements confirming that they were neither present in the Assembly nor did they issue an authority written or otherwise for any members to vote on their behalf. In this regard, Counsel for the Governor referred to the Standing Order 67 of the Nyamira County Assembly Standing Orders, which requires the decision of the Assembly be made by members present and voting. Counsel argued that the act of proxy voting was expressly prohibited and was a nullity as it contravened Standing Order 67 of the Nyamira County Standing Orders and the principles of representative democracy. It was Council's case that the unauthorized casting of votes in the names of absent members without the authority constituted fraudulent misrepresentation, forgery, and impersonation, further vitiating the entire process. As such, the Governor takes the view that the maximum number of voting MCAs would have been 19 MCAs. The Governor concludes that the required statutory threshold of 24 members of the County Assembly to support the motion was not achieved. In response, Counsel for the County Assembly stated that the delegation of voting by proxy was carried out in a right manner, and further that the proxy letters were available as evidence of the said delegation. Now, in support of this submission, Counsel referred to the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA, page 696, which set out the threshold for a preliminary objection. In particular, Counsel stated that the issues raised and in question, that is the number of persons who voted, was a contested fact that ought not to be argued at the preliminary stage. He further stated that although the Governor's Council had indicated that there was evidence of affidavits sworn by 4 members of the County Assembly, averring that they did not delegate such authority, the County Assembly would, at the hearing, provide evidence of mobile telephone and email communication to counter this allegation. It was therefore not possible for the Senate to make a determination on the matter at the preliminary stage without hearing evidence on the matter. Now, Counsel further argued that although proxy voting was not expressly provided for in the standing orders, the Speaker of the Nyamira County Assembly had exercised the discretion provided for Standing Order 1 of the Nyamira County Assembly Standing Orders to allow for the proxy voting. He further stated that although the standing orders were silent in expressly providing for proxy voting, this did not bar the use of proxy voting in the Assembly. Now, Honorable Senators, following the oral submissions on the preliminary objection and the responses, Senator Edwin Sifuna, Senator Enoch Wambua, and Senator Boni Halwale sought various clarifications from Council, including on the relationship between provisions on the Constitution, on vacation of office by members of Parliament or county assemblies, vis-a-vis the provisions of law as that set out threshold for voting on a matter, at what point the membership of a county assembly is determined after election, or whether this is a moving target, and whether it will not be prudent to give the county assembly the opportunity to adduce evidence on the matters raised in the preliminary objection in the main hearing. Subsequently, the respective council gave the responses to the questions and clarifications sought by honorable senators. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1, whether the preliminary objection raised qualifies as a preliminary objection, properly so called, and whether therefore its determination must precede the further progress of the current impeachment process. And 2, if the answer to the first issue is in the affirmative, then whether the 2/3 threshold required for voting on the impeachment motion of the County Assembly was met. Now, honorable senators, I shall commence with the first question, which is whether the preliminary objection raised qualifies as a preliminary objection properly so called, and whether therefore its determination must precede the further progress of the current impeachment process. As you will recall, the Senate has previously been confronted with this question in previous impeachment proceedings. The question of what constitutes a preliminary objection is set out in the leading case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors. And this is what, in that matter, the court held. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of the pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are on the objection to the jurisdiction of the court, or a plea of the limitation or submission that the parties are bound by contract giving rise to the suit to refer the dispute to arbitration. A preliminary objection raises a pure point of law, which is argued on the assumption that all facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. Now, honorable senators, in light of this similar decision, it is now well settled and established in our practice that a preliminary objection does not require evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained by the use of evidence to be adduced. Reference has been variously made by counsel for the governor and counsel for the county assembly to the jurisprudence that has been laid down by this house in the two Kericho impeachment matters, now commonly referred to as Kericho 1 and Kericho 2, in which the Senate arrived at different conclusions on the nature of preliminary objection and the appropriate place at which to make a determination. In fact, there was no contradiction in the determinations made by the House in Kericho 1 and Kericho 2. In Kericho 1, the Senate determined that a classical preliminary objection was one which is purely on matter of law and which required no evidence to be adduced for its determination. In that case, it was not in contention that the number of county assembly members who had voted in support of the impeachment motion was 31. It was also not in contention that the total number of Kericho County Assembly members was 47. The only question was whether 31 members constituted the two-thirds threshold as required by law. In Kericho 2, on the other hand, the question was whether some of the county assembly members alleged to have voted in support of the motion did actually vote. This was a matter requiring evidence to be adduced, including the examination and cross-examination of the said county assembly members, and accordingly, this was not a matter that could be determined at a preliminary level without hearing the evidence. Kericho 2 was therefore ruled to belong to the second category of preliminary objection that can only be reasonably subsumed in the full hearing, but for which a determination by the Senate would have to be made at the end before the proceedings to vote on the charges. The question, therefore, is whether the current preliminary objection belongs to the jurisprudence of Kericho 1 or Kericho 2. Now, honorable senators, in the current impeachment proceedings, it is not in contention that there were 19 members in the County Assembly of Nyamira present and voting at the time of impeachment. Secondly, although there is contestation about the validity of the votes purportedly cast by proxy by another 4 members, there is no contestation that the total number of members who voted did not exceed 23 members. The County Assembly, by its own admission, has submitted a list of 23 members as having supported the impeachment. The governor's side, on the other hand, object to this impeachment on the basis that the correct threshold should have been 24 members rather than any lesser number. What is in contention, therefore, is whether the threshold of members required to have voted in the matter is 24 or 23 or lesser number. What is additionally in contention is whether in reckoning the two-thirds threshold, the number of members of the County Assembly is to be applied as 35 or 32. The legal question in contention is whether the number of legislators of the County Assembly remains fixed and unaffected by any vacancies for the purposes of reckoning thresholds, or whether, as Councillor Katwa Keegan for the County Assembly argues, it is a moving target. That cannot be reckoned in advance and depends on the membership of the Assembly at a particular time having subtracted any vacancies existing. Now, honorable senators will appreciate that this is a constitutional and legal questions of the most fundamental ramifications, the decision on which reverberate far and wide and well beyond Nyamira County Assembly, and possibly including this chamber, where at various times and for various reasons, we have had vacancies. The decision the Senate takes on this legal question will no doubt bind us going forward in the manner in which we reckon delegations for purposes of voting when there are vacancies in the Senate. From this perspective, it is clear to me that even though a number of matters of fact were raised by the County Assembly, preliminary objections and fundamental legal questions of threshold, and whether the correct number of delegations that were required to impeach the governor of Nyamira County at the time of the impeachment was undertaken was 24 or 23 or any